Hi students, how's everybody doing? I wanted to submit this recording or to make this recording for chapter 1 of our criminal law textbook. So let's get to it. First off, there are a couple of topics we have to address whenever we get into a criminal law class. First, to start, I have to separate and I have to introduce the difference between criminal law and civil law. Civil law is law that involves issues involving private people. Typically, one person has wronged another person over usually a financial matter, something regarding money. And that's what we usually think of when we hear civil law. The main thing that distinguishes civil law from criminal law is this idea that it's a person or a business having an issue with another person or another business. It's a private matter. This is different from criminal law. Criminal law involves the state government, or the federal government, initiating a case, a criminal case, against a defendant for breaking a law that wrongs the entire public. So while civil law involves an issue that typically affects a small number of people, criminal law involves an issue where an individual has wronged all of society. Now, sometimes people get lost in that, right? If somebody gets murdered, how is that loss of life an issue that affects all of society? Well, the answer to that is that from the moment that person was murdered, from the moment the victim is murdered, that person's never going to be able to interact with anybody again. So on issues like, a future family, future friends, future interactions with anybody that person would have come into contact had they not been murdered, shows how all of society has been wronged by the loss of that person's life through the murder. So that's a very quick introduction between helping distinguish between criminal law and civil law. There are other differences, but we're not going to get into them just now. But I did want to start off a criminal law class explaining to you guys the difference between criminal law and civil law. All right. Now, there are other concepts that I want you to keep in mind. Oh, there we go. It is talked about in the textbook. So I actually will continue talking about it. There's a couple of other differences between criminal law and civil law. The wrong or the consequence that a person who breaks a criminal law receives is much greater than the consequence they receive if they break a civil law. Okay. Criminal law consequences may include the death penalty. They may include jail time. They may include house arrest, rehabilitation, fines. Okay. While typically civil law consequences are going to be limited to money. So in a civil law case, if you left a banana peel on your store and somebody tripped and fell and they suffered head injuries, well, the consequences for your accident in not being careful in how you operated your store, the consequences are not going to be criminal. They're going to be monetary, financial, meaning that you're going to have to pay the person that you injured a certain amount of money for the loss that you caused them. All right. Now, when you're looking at civil law and criminal law, another difference is the party that's going to start the case is going to be different if you're looking at it from a civil law perspective or a criminal law perspective. So in a criminal law case, the party that's going to start that case is going to always be the state. And we call that the state. It doesn't have to necessarily be a state like Florida or Michigan, but when we use the term the state, that's a broad term we use to describe either the state government or the federal government. So if you hear me say the words the state, I could be talking about the United States government or the individual government of any one of the states in the United States. Well, the party that starts a criminal case is always going to be the state. And the question is why? Well, why is it that the victim of a criminal case doesn't start the case? Why don't they start the case in court? Because again, like I told you earlier, in a criminal case, the party, the entire, all of society is affected. And we're going to discuss how there are different reasons for why we punish somebody. But ultimately, the main purpose of punishment for a criminal case is society, in some way, shape, or form, to either protect society, for society to send the message to that person that what they did was wrong, but it's about society. If you allow an individual who has been wronged in a criminal case, let's say that there has been a person who has had an assault, meaning that they have had somebody has tried to physically touch them in an aggressive or inappropriate manner. Well, if somebody's the victim of assault, it's true that that's the person who's the victim. However, all of society gets together to want to address the wrong of that victim. This is different from in a civil case. In a civil case, you're going to discover that the problem is not about how society gets together to address a wrong that's been committed towards a victim, but rather in a civil case, it's going to be about financially compensating, giving the money to a person who is the victim of a civil law that's been broken. Okay. That's going to be it for now in terms of the differences between criminal and civil law. I don't want to get into many more differences, although there are more. One of the ones that we will discuss at the end of this lecture is going to be the burden of proof when I get to that, but I'm not going to get to talking about burden of proof just yet. Now, why is it that we have criminal law? What's the purpose of criminal law in general? And more specifically, why do we punish people for breaking criminal laws? Well, there are two main theories for why we punish criminals. The first theory is known as retribution. Retribution is the theory of punishment that looks backwards in time, looks to the past as the justification for why we punish somebody. Okay? So if you believe in retribution, which is the oldest theory of punishment, you're going to listen to arguments like, hey, the reason we punish this person is because they deserved it, they earned it, they did something wrong, right? Phrases like an eye for an eye, which are found not just in the Bible, but also Hammurabi's Code, also express this concept of retribution, right? You did something wrong. Justice and fairness require for you to have to pay back a debt that you've made through your actions, through your past actions, to all of society. And that's why we're going to punish you. That's the concept known as retribution. Again, we look backwards in time. And so the punishment is going to be based off of how bad what you did in the past was. And the idea is that you're going to get what you deserve for what you did in the past. Again, retribution as a theory of punishment focuses on past behavior, focuses on the past. That's its main purpose, looking backwards. You compare that to the second theory of punishment. The second theory of punishment is known as utilitarianism. Okay, utilitarian. Some people call it the utilitarian theory of punishment. Utilitarianism, similar words. What does it mean to be someone who supports utilitarianism? Well, utilitarianism is the theory of punishment that looks forward as a justification for why a person's going to receive punishment for breaking a criminal law. So if you are a person that supports utilitarianism, the reason you do so, and the reason you believe in punishment rather, is because you believe that there is a reason looking forward into the future that justifies, that explains, or that excuses why society needs to punish that individual, or why society needs to give consequences to that individual that has committed a crime. Now, within utilitarianism, there are three sub-points. You can think of them as three sub-theories, all of them belonging to the utilitarian, because what's going to keep them all together, what's going to be the common theme among all of them, is that they're looking all forward to the future. Okay. Now, the first theory, or the first sub-theory within utilitarianism, is what is known as incapacitation. Okay, what does it mean to incapacitate somebody? Well, if you're incapacitated, what that means is that you're no longer allowed to move. So the first sub-theory within utilitarianism as to why we punish people says we incapacitate the prisoner or the criminal so that they can no longer continue being a threat to society for as long as they are in prison. And that's why we punish somebody. That's what somebody who believes in incapacitation argues, that the reason we punish somebody is, hey, listen, we want to keep society safe from the criminal. And we're going to do so for however long we need to keep society safe from that person, depending on how much of a threat they pose to society in the future. Again, remember, incapacitation, a utilitarian principle or a utilitarian sub-theory of punishment. That's the first one. The second one is what is known as deterrence. What is deterrence? Deterrence is the idea that we're going to make an example out of that criminal so that other members of society don't get any horrible ideas and try to repeat the issue or the crime that person did in the future. That's what deterrence is. Deterrence is this notion that, hey, we're going to make an example out of you. So if somebody is seen driving recklessly and just Grand Theft Auto style, killing everybody on the sidewalks, the reason we're going to punish that person is not just because of what they did or keeping society safe from that person, but if we're only focusing on deterrence, the reason that we're going to punish that person is to send a message to every other GTA driver out there that they don't get any ideas to start driving recklessly and start trying to kill people on sidewalks as they speed along. Okay. Again, with deterrence, the issue is about sending a message to the rest of society that the behavior that the criminal committed is not accepted. It's not tolerable. The last sub-theory of punishment, of utilitarian thought, is what is known as rehabilitation. Simply put, rehab is to fix somebody. So if we're punishing somebody, the consequences we're going to give them, looking forward in the future again, because remember, this is still a utilitarian theory, is we're trying to fix the person so that they don't wrong, so that they can become whole in the future. And so punishment is going to be limited to just simply whatever the person needs so that when they finish their punishment, they become whole again. They become a good member of society, a functioning member of society. Now, realize again, all of these sub-theories of utilitarianism, whether it's incapacitation, deterrence, or rehabilitation, all of them look forward to the future as the reason for why the consequences are being given to the criminal. Don't get them confused with retribution, which looks backward. Now, the truth is, we all have a little bit of retribution and a little bit of utilitarianism. Most people do, anyway. And most people, they kind of struggle with which one they want to go with. Sometimes we feel a little bit more, that we believe a little bit more in retribution. Sometimes we believe a little bit more in utilitarianism, so on and so forth, and that's perfectly fine. But these theories help us understand why we have punishment and why we punish criminals in general. Now, the next question that we have to answer is, how does morality play a role in criminal law? Okay. And it's a controversial topic because some people want to argue that morality shouldn't have a role in criminal law, and some people argue that morality cannot be removed from criminal law, that criminal law is rooted in morality. All right. Broadly speaking, we divide our crimes, when we think about them, into acts that are considered evil because the acts themselves are evil. We call this mala in se, M-A-L-A space I-N space S-E, mala in se, which means evil in and of themselves. And we also have a different name for it, which we also have a different way of looking at our crimes, which we can call mala prohibita. Mala prohibita simply means the crime is evil only because they are prohibited by law, but they're not necessarily evil. In other words, they're not necessarily morally wrong in and of themselves. So mala in se crimes, we typically think of crimes like murder, rape, assault, burglary, arson. And these are acts that all of society typically agrees, hey, listen, these are really evil acts. These are wrong. Nobody was going to sit there and say, hey, murder is good. Murder is bad because morally we know that it's bad. And we call these kind of crimes mala in se. Mala prohibita are evil because the law says they're evil. Some people would consider acts, for example, like private sexual acts between consenting adults, like prostitution, as being an example of mala prohibita. Some people would also consider laws dealing with the regulation of alcohol and drugs as being mala prohibita, the idea that there's nothing necessarily evil in and of itself of the fact that a 20-year-old is drinking a glass of wine, but society has said that this is not a good thing, so therefore we don't allow it. But it's not that the act in and of itself is evil. If that morally, a 20-year-old drinking a glass of wine is not necessarily an evil issue. In fact, in all of Europe, the drinking age in many places is 16, 15, even in some places, I think 14, the age for legal consumption of alcohol. So it's not that, unlike murder, unlike rape, which are real evil acts in and of themselves, and we can all agree that they're evil on their own, mala in se. These other crimes that we've described as being mala prohibita, the reason that we say that they're bad has nothing to do with the evilness or the immorality of the act itself, but rather it's an issue that society has said, hey, look, we don't accept these kind of behaviors for whatever reason. And we call them mala prohibita. All right. Now, there is another term that we want to get. A lot of this first chapter is going to be just going over certain definitions so that we can all be on the same page. Another definition that we're going to give you is what is known as the principle of legality. What does legality mean? What does this principle of legality mean? What the textbook says is that no act may be punished as a crime unless it was defined as a crime and punishment was provided by the state or federal government prior to the commission of the act. So in simple terms, what does this mean? What does this mean? How do we apply this? Well, the only way that a behavior can be punished is if there has been a law written out prior to that behavior having taken place, describing that type of behavior as being a criminal issue, as being a crime, with a specific degree of consequence or punishment. Otherwise, we're not going to punish you. The idea is that we can only punish criminal behavior that we have specifically or expressly outlawed in our legal system, in our laws. And that's the concept that is known as the principle of legality. Now, when you're talking about criminal law, you're going to encounter the court system. Now, there's a few terms that you should become familiar with when analyzing our court system. You may have heard these from American government classes or from civics classes. The first term is called judicial review. And this is the power that the courts have to analyze the legality of laws. Okay, and not just laws, the legality of acts. And by legality in this aspect, I'm saying whether those laws or whether these acts done by Congress or by the executive branch or even by the judicial branch, whether they violate the US Constitution or whether they violate federal laws. And that's the concept that is known as judicial review. Now, the reason that judicial review is very important is because if a person commits a crime, but the crime involves behavior that or the way that the law was written regarding that crime is unfair and violates what the Constitution says are our constitutional rights, then that law will become subject to judicial review, and courts will strike it down, saying that that law is not valid. And the person who had been found guilty of breaking that law will get to walk and not be found and not have to suffer any criminal consequences, because when judicial review was applied, the law that was used to convict that defendant was found to be invalid, unconstitutional. And so this concept of judicial review is going to be very important, as are our judges in our court system, because our judges in our court system many times are going to be the ones who are going to decide for issues like, for example, sentencing, how long a criminal or what type of punishment a criminal should receive for the criminal law that they committed, that they broke. Now, the textbook wants to make sure that we specify, and I want to clarify this. We have a federalist government in the United States. What that means is that we have laws that are passed by on a federal level. But we also have laws that are passed at the state level. And so when you think about that, what that means is there's going to be criminal and civil laws that are passed by Congress for the federal government and for all of the United States. But there are also going to be state laws that are passed by state government, by state legislatures and state governments that are going to deal with criminal issues as well. And so in some instances, they're going to be crimes that are, or behaviors that can violate both federal law and state law. And, it's important that you guys keep that in mind. And it's important that you understand that when you're dealing with a state criminal issue, you could easily be, depending on what crime you committed and what laws you broke, you can be dealing with the state government, the federal government, or both. All right. Now, what this is known as jurisdiction. Okay. And jurisdiction in this concept is going to be limited by geography. Okay. So let's give you a definition of jurisdiction so that everybody stays on the same page and nobody gets confused. The textbook defines jurisdiction as the lawful exercise of authority and the geographic area or subject matter in which authority may be exercised. And the textbook example that they give is how cops can only operate, for example, within the city that they are employed, meaning that a Broward County sheriff cannot come into Miami-Dade County and start trying to and pull somebody over for speeding. What they do, by the way, in case you're wondering, is they will call, many times they really want to get you, they'll call the department of somebody let's say that you're in Miami Shores, they'll call Miami Shores Police Department and they'll see if a police officer is willing to go out and try to get that guy who's speeding. But the Broward County cop cannot cannot pull over, cannot give a ticket. Why not? That's not their jurisdiction. That's not their area where they operate. Well, within a criminal law system, the same logic applies. Some criminal laws are going to be only based off of what the state of Florida has said. And so in some instances, you're going to find situations where the state of Florida punishes a specific act, but maybe the state of Georgia doesn't on a criminal level. And so if I right now were to commit that crime in Georgia, what would be defined as a crime in Florida, but if I do it in Georgia, Florida cannot punish me for it because I did it in Georgia. And in Georgia, that specific act is not criminalized. It's not considered a criminal issue. And so jurisdiction matters, right? Making sure that the criminal laws are applied geographically to the area where people behave, where people are committing their acts. I cannot have the state laws of Hawaii be used to punish me in Florida. If I break a criminal law in Florida, only Florida laws may be used to punish me. And that's the concept of jurisdiction. Now, another way that jurisdiction exists or is applied is on what type of criminal issues courts may deal with. What do I mean by that? Let me be a little bit more precise with that. There are going to be scenarios where some criminal courts in Florida are going to have jurisdiction over small criminal matters. For example, if somebody steals a $5 pen from Target, that would be considered a minor criminal issue. It's still a criminal issue, but it would be considered, by comparison, a minor criminal issue. Well, for breaking that criminal law, some courts are going to deal with those minor issues. The term that we have for this is what's known as misdemeanors. So misdemeanors are when a person commits a crime where the maximum punishment cannot be over a year. So the maximum punishment that a court can give you if you're found guilty for committing a misdemeanor is never going to be over a year. We call that a misdemeanor. Realize it doesn't mean that they have to give you a year. They can choose to not give you jail time. They can choose to only give you 20 community service hours. But if the judge was to give you the worst punishment they could give you, the maximum would be a year. That's because a misdemeanor, that's the maximum punishment for a misdemeanor. With a felony, those are more serious criminal issues. Felonies involve acts where the maximum punishment for having committed those acts is over a year. It could be a life imprisonment. It could be 20 years. It could be 18 months, the maximum punishment. Now, understand something. Just because you've committed a felony doesn't mean that you're going to receive the maximum punishment. Again, the judge may choose to not give you jail time, or the judge may choose to give you 6 months. But if the judge wanted to, and you've committed a felony, they can give you a maximum punishment that is over a year. Okay? An easy way of keeping in mind misdemeanors and felonies, and how I've always taught it, if you've committed a misdemeanor, you messed up. Mess ups are bad. Messed up, misdemeanor, mess ups. If you commit a felony, you effed up. F-ups are much worse than mess ups. And so felonies are much worse and more serious in nature than misdemeanors. Now, a couple of other definitions that I want to make sure we are all familiar with. The lawyer who represents the government in a criminal case, we call that the prosecution, the prosecuting attorney, also the state attorney. All three terms can be used interchangeably. Okay, the prosecution, the prosecutor, the prosecuting attorney, the state attorney. And now I said 4 terms. And that's the lawyer who's going to work on behalf of the state, representing the state, in trying to punish an individual for committing a crime. The lawyer who represents the criminal is called a defense attorney, okay? And that's the person that represents the accused. If you hear a U.S. attorney, sometimes that's the term U.S. attorney is used for the federal prosecutor of in a federal case, okay? What else do I want to make sure I look for? Okay, let's define ex post facto and bill of attainder. These two terms are very important for you to keep in mind. All right. Ex post facto is what makes sure that the principle of legality isn't abused. So ex post facto means that a state may not pass a law to retroactively punish somebody for behavior that was legal at the time they committed. That's what an ex post facto law is. The idea that, hey, I want to go after somebody and punish them for something they did in the past, but there was no law in the past that would have been used or that could have been used to punish that person. So now we're going to create a law to try to punish them retroactively, criminally, for what they did. And under the U.S. Constitution, those laws are not allowed. We call those laws ex post facto laws, and they're not allowed. They violate the U.S. Constitution. Bill of attainder, on the other hand, is when a person receives punishment from the government without having had a trial. And bills of attainder are also not allowed under the US Constitution. We believe that anybody who is going to get punished has the right to their day in court to present their evidence, to call witnesses. All of this is your constitutional rights. And so the government may never put you in jail without having given you a trial and a chance to have your side heard before a judge and a jury. And that's the concept of bill of attainder, the idea that there can never be a law or a punishment that a person receives without having first had a trial. And if that happens, it's a violation of the US Constitution. There's going to be another restriction when a person is punished criminally, and that's the restriction found within the 8th Amendment of the US Constitution. The 8th Amendment of the US Constitution, what it says is that cruel and unusual punishment is never going to be allowed. Okay, so there's going to be a lot of disagreement as to what we define cruel and unusual. And you're going to discover that over time, our society has shifted in its definition of what is actually considered to be cruel and unusual. 60 years ago, hanging was not considered cruel and unusual. So if you received the death penalty, you could get hung. Even maybe as recently as 50, 40 years ago, the electric chair was a common means of giving somebody the death penalty, and that wasn't an issue, right? It wasn't considered cruel and unusual. Now, those two forms of death penalty are considered cruel and unusual. It used to be the firing squad, also early 1900s still. No longer applies. Even the whole concept of the death penalty, some people argue, and I suspect that we live in a society that little by little is actually becoming more convinced that the concept of the death penalty in and of itself is a type of cruel and unusual punishment. Whereas a couple of hundred years ago, at the time when our country's founding was taking place, our founding fathers would never have considered the death penalty to have been a cruel and unusual punishment. But we are shifting little by little in that direction. I believe that's my opinion. All right. Now, in the United States, and if you've taken me for business law, you've seen this before, or if you've ever taken any of my law classes in high school, you've seen this before. There is an issue where we have to explain how our judicial court systems work. And what we believe in the United States is a system called the adversarial system, or the adversary system. And what this means is, what's the role of the judge? Let me take a step back. Europe and the United States define the role of a judge in a criminal case very differently. In Europe, the judge gets to actually make themselves a part of the trial. They get to ask questions of witnesses. They get to demand evidence be produced. They get to make arguments midway through the trial, or trying to find evidence, trying to find witnesses, trying to find facts. We call that the inquisitional or inquisitorial system. That's not how we do it in the US. In the US, the judge does not get actively involved in the details of how the prosecution runs its case or how the defense runs its case. The judge just sits back and calls shots. They're an umpire. When one side complains about evidence that's being used, the judge makes a ruling on that. When one side requests an extension of time for the trial, the judge is the one that's going to make a decision on whether we should extend the trial. The judge sits impartially in the United States simply as a neutral party. And that's the system, we call that system the adversarial or the adversary system. We call it adversary or adversarial because there's two adversaries, two opponents in our legal system: the prosecution and the defendant. And we believe that the truth is going to come out when both of those sides fight to the best of their ability. And because one of the main points, if not the main issue of our court system, is to try and find the truth in any given situation, the adversarial system supporters argue that by giving both sides letting those both sides fight it out and not getting involved in tipping the scales one way or another, justice is going to come out. In Europe, they see it a little bit different. In Europe, they think that if one side's getting beat up, but it's not because they're wrong, but because they're facing a stronger and better opponent, the judge should get involved. We don't believe that in the United States. We call this system the adversarial system. All right. A couple of other things before we finish. We're getting closer to that time when we finish the lecture today. I told you that I was going to get to it near the end of class, another difference between criminal law and civil law. And what that difference is, it's what's known as the burden of proof. What do we mean by that? What does that term mean? Burden of proof is simply, we can label it differently, who has the obligation of proving the case. Now, I always tell my students that the party that initiates a case, the party that starts a case, has the obligation of proving almost everything within that case. Not everything, but usually most of the things in a case. So in a civil case, the plaintiff, which is the name we give to the private person that starts a case, they have the burden of proving the elements of the case. In a criminal case, on the other hand, the state, which starts the case, has the burden of proving the case, which means that the defense never has to prove their non-guilt. Never. The state has the burden of convincing the jury, really, usually it's going to be the jury, that the defendant is guilty of a crime. And if the state fails to provide enough evidence to show the guilt of that person, even if the individual is guilty, the jury has to return a verdict of not guilty. And that's because the state failed to provide and to meet their obligation, their burden of proving the case. That's a term we call burden of proof. Now, in criminal law and in civil law, we define burden of proof very differently. In civil law, the burden of proof is simply convincing the jury by one hair more that the plaintiff, the private party that started the civil case, is right in how they claim the defendant has wronged them and that they are owed money. We call that burden of proof preponderance of the evidence. Preponderance of the evidence. We can look at it mathematically as 50% plus 1, a little bit over 50%. Anything over 50%. And if the jury believes it's over 50% more likely that the defendant wronged the plaintiff, then the defendant is called liable, and the defendant has to pay the plaintiff whatever it is. In a criminal case, we use a different term, and it's a different burden of proof altogether. The burden of proof in a criminal case is called beyond a reasonable doubt. What does that mean? This means that there cannot be any logical doubt in the mind of the jury that the defendant's actions are criminal, based off of the definition that the jury receives on what a crime, on what that crime is. But every single word found in that crime, the state has to prove the defendant did, beyond any logical doubt, in order for the jury to find the defendant guilty, in order for the state to succeed in its case. And the state, remember, has the obligation of proving their case, the burden of proving their case. So beyond a reasonable doubt is a much higher threshold of evidence that the state must produce and that the state must convince a jury by, compared to a civil case. Why do we do that? Because we believe in the United States and most of the world that it is better for a guilty person to walk and be found not guilty than for somebody who is innocent to be wrongly found guilty. And so we believe that we have to put all the pressure on the state to succeed in convincing the jury that the defendant has committed the crime. Now, I keep saying jury. I should very quickly clarify why I keep mentioning jury. What is the role of a jury in a trial? The jury finds out the facts. The jury makes a decision on what the facts are. They hear two versions of stories, two different stories, and the jury says, this is the one we believe. If it's the state and they believe that the state's version of the story is true beyond any logical doubt, then the jury is the one that makes the decision of guilty. If they don't, they make a decision of not guilty. Understand something, the jury never makes a ruling or a decision called innocent. The jury never returns a verdict of innocence. The verdicts are guilty or not guilty. There's another one, but that's for another day, and that's not something that the jury would consider. All right. So those are the two burdens of proof. And then a criminal case, the burden of proof is much higher because we'd want to make sure that that it's not just, I think he did it. No. We have to be very confident that the person we have accused of committing a crime did commit the crime, and as a result is worthy of receiving criminal punishment and being found guilty for their crime. It's not just he looks like he did it. I think he did it. That's not enough. We don't want any logical doubt. Now, we call that any logical doubt, but understand that logical doubt or reasonable doubt is not the same thing as conceivable doubt. What is a conceivable doubt? A conceivable doubt is a doubt that we can imagine in our head. So if, for example, there is evidence of me murdering a colleague of mine, there's video, there's pictures, there's a recording, there's the murder weapon with my DNA on it, there's eyewitnesses. The state has a pretty solid case against me. I don't get a chance, if you really think about it, to do the following, though. To tell the jury during the trial, I know the evidence looks bad, guys, but I was abducted by aliens. They took over my body. They body snatched me. And it really was aliens who looked like me that murdered my colleague. We can imagine that, right? Like we can imagine that because we have very strong imaginations. That's not a logical doubt. The state does not have to overcome any doubt that I can create that's made up, we can imagine. The state only has to make sure that there are no logical doubts. Okay. And so because in that example, there probably wouldn't be logical doubts or reasonable doubts as to my guilt, the jury will find a verdict of not guilty, despite the fact that I could have made up an imagined doubt. All right. Sometimes juries, lawyers, or people within the trial misbehave and they mess up and they do something that they shouldn't have done. And we call those instances, if something like that happens, the judge is going to declare something that is known as a mistrial. What is a mistrial? A mistrial is an incomplete trial. And so after that, what that means is after a mistrial, the judge is going to give the state the chance of starting a new trial from scratch again with a new jury, or to dismiss the case. But that's what a mistrial is. Also, there are going to be times where the state meets its burden of proof. And there is no reasonable way that a jury could really say not guilty. And yet they still return a verdict of not guilty. Why? Because of a concept known as jury nullification. Remember that in the United States, like I said to you, almost all crimes are always going to go to the jury. Every criminal defendant has the right to be tried by a jury of their peers, meaning that every person in a criminal trial always has the right of having a jury present to decide their guilt or non-guilt. And in some instances, the jury might realize that the facts are such that the defendant did commit a crime. However, they don't want to return a guilty verdict. They like the defendant, they sympathize with the defendant, they think that it's not fair given the facts to punish this person. Any number of reasons. We call that jury nullification. Why? The jury has nullified the crime. All right. Frequently, no, I'm not going to say. I'm not going to go over. And that's it for this chapter. If any of you have any questions, feel free to email me, let me know. And see you guys next week. Bye, everybody. Stay safe.